Without the provisional measures requested, Pakistan will execute Mr. Kulbhushan Jhadav before the court can consider the merits of India's claims, and India will forever be deprived of the opportunity to vindicate its rights. End of quote. I shall now ask the Registrar to read out the passage from the request specifying the provisional measures which the Government of India is asking the court to indicate.
India respectfully requests that pending final judgment in this case the court indicates: A. That the government of the Islamic Republic of Pakistan take all measures necessary to ensure that Mr. Kulbhushan Jhadav is not executed. B. That the government of the Islamic Republic of Pakistan report to the court the action it has taken in pursuance of subparagraph A. And C. That the government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the rights of the Republic of India or Mr. Kulbhushan Jhadav with respect of any decision the court may render on the merits of the case.
On 8 May 2017, immediately after the filing of the application and request for the indication of provisional measures, the Registrar, in accordance with Article 40, Paragraph 2 of the Statute, and Articles 38, Paragraph 4 and 73, Paragraph 2 of the Rules of Court, transmitted certified copies thereof to the government of the Islamic Republic of Pakistan. He also notified the Secretary General of the United Nations of the filing of these documents by India. By a letter dated the 9th of May 2017, referring to Article 74, Paragraph 4 of the Rules of Court, in my capacity as President of the Court, I called upon the Islamic Republic of Pakistan, I quote, to act in such a way as will enable any court the court may make on the request for indication of provisional measures to have its appropriate effects. End of quote. According to Article 74 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Referring to the, I quote, the extreme gravity and immediacy of the threat, end of quote, India asked the court to render an order on its request without a hearing. The court decided to hold a hearing in order to allow both parties to present their arguments. Given the circumstances, the court decided that the oral proceedings contemplated in Article 74, Paragraph 3 of the Rules of Court should be brief and held on rather short notice on 15th May 2017, today. I note the presence before the court of the agents and counsel of the two parties. The court will hear India, which has submitted the request this morning until 11:30 a.m. It will hear Pakistan this afternoon from 3 to 4:30 p.m. The hearings on India's request for the indication of provisional measures will be closed at the conclusion of this afternoon's session. For the purposes of these oral arguments, each of the parties will have available to it a full 90-minute sitting. India may, if required, avail itself of a short extension beyond 11:30 a.m. this morning, in view of the time taken up by the opening part of these oral proceedings. The parties are, of course, not required to use the full amount of time allotted to them. Before giving the floor to the agent of the Republic of India, Dr. Deepak Mittal, I wish to draw attention to Practice Direction 11, which states inter alia that parties should, I quote, in their oral pleadings on requests for provisional measures, limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. End of quote. I now call upon Dr. Deepak Mittal, agent of the Republic of India.
Mr. President and honorable members of the court, it is indeed a great honor for me to appear today before this august court on behalf of the Republic of India as India's agent at the oral hearings on India's request for indication of provisional measures in the proceedings instituted by India against the Islamic Republic of Pakistan on 8 May 2017. This case concerns an Indian national, Mr. Kulbhushan Jhadav, who has been awarded death sentence by a military court in Pakistan in egregious violation of the rights of consular access guaranteed by Article 36, Paragraph 1 of the Vienna Convention on Consular Relations 1963. At the outset, I would like to thank the court and the President for the timely decision and action to exercise the powers conferred upon him under Article 74, Paragraph 4 of the Rules of Court and send an urgent communication on 9 May to the Prime Minister of the Islamic Republic of Pakistan, calling upon the government of Pakistan to act in such a way as will enable any order the court may make on India's request for the indication of provisional measures to have its appropriate effects. Mr. President, members of the court, the fact that the hearing is taking place today within 7 days of the institution of proceedings by India is testament to the recognition of the urgency by the court in the case of an innocent Indian national, Mr. Jhadav, who, incarcerated in Pakistan for more than a year on concocted charges, deprived of his rights and protection accorded under the Vienna Convention, being held incommunicado without contact with his family and the home state, is facing imminent execution. All notions of human rights are now considered by the global community as basic to behavior in civilized nations have been thrown to the winds. By this timely action by the President and the court, this institution has provided succor not just to India and to its beleaguered national and his family, but also has given hope to 1.25 billion people of India and hope to the old mother and father of the innocent Indian national that justice would be meted out to their innocent son by this highest seat of justice and a precious life will be saved. Today, accompanied by my colleagues, I appear before the court on behalf of the Republic of India with the hope that the court would indicate provisional measures so that the death sentence which has been awarded to Mr. Jhadav through a farcical trial in a Pakistan military court in violation of the rights guaranteed to Mr. Jhadav and India under Article 36, Paragraph 1 of the Vienna Convention would be set aside and not carried out pending final decision of the court on India's application. I take this opportunity to introduce the members of my delegation. They are Mr. V.D. Sharma, co-agent, Mr. Harish Salve, counsel, Ms. Kajal Bhatt, advisor, Ms. Chetna Rai, junior counsel. I would now present brief facts of the case, which would be further elaborated upon during the hearing. India was informed on 25 March 2016 that an Indian national was allegedly arrested on 3 March 2016. India, on that very day, sought consular access to the said individual. The request did not evoke any response. On 30 March 2016, India sent a reminder reiterating the request for consular access at the earliest. Despite a number of such reminders for consular access sent by India, there has been no response and all these requests fell on deaf ears. Meanwhile, on 23 January 2017, India received from Pakistan a request for assistance in investigation process. Subsequently, on 21 March 2017, almost a year after India's first request for consular access, Pakistan formally communicated to India that consular access to Mr. Jhadav, I quote, shall be considered in the light of Indian side's response to Pakistan's request for assistance in the investigation process, unquote. India responded that consular access would be an essential prerequisite in order to verify the facts and understand the circumstances of Mr. Jadav's presence in Pakistan. On 10 April 2017, India learned from press reports that Pakistan proceeded to have a military trial against Mr. Jhadav and he was sentenced to death purportedly on the basis of a confessional statement, and that this sentence was confirmed by the Chief of the Army Staff of Pakistan. Ironically, later in the day, after that sentence has been awarded and confirmed, India received a note verbal from Pakistan reiterating the condition for considering consular access in return for India providing assistance in the investigation process. India responded the same day, highlighting that the offer of conditional grant of consular access after award and confirmation of death sentence reflected the farcical nature of the proceedings and so-called trial by a Pakistan military court against Mr. Jhadav. Despite requests by India, Pakistan has not provided any information or documents, including the charge sheet, proceedings of the court of inquiry, the summary of evidence, the judgment. Request for appointment of a defense lawyer for Mr. Jhadav has also not elicited any response. The mother of Mr. Jhadav, even in the absence of any document, submitted an appeal to the Court of Appeal and a petition to the federal government of Pakistan. This appeal was filed even though it was unable to address any of the issues that may have been put against Mr. Jhadav in the judgment and order of conviction. It was an act of desperation by grieving parents. The parents of Mr. Jhadav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 27 April 2017 for his personal intervention in the matter, but there has been no response. All that we know is what we have seen in the media in Pakistan. Pakistan officials have been reported as having said clearly that Mr. Jhadav would not be provided consular access. Mr. President, members of the court, India believes that the farcical nature of the proceedings and unjust trial by a Pakistan military court in egregious violation of the rights of consular access under the Vienna Convention has led to serious miscarriage of justice. It is clear that Mr. Jhadav has been denied the right to be defended by a legal counsel of his choice. He has not been informed of his right to seek consular access. His conviction and death sentence appears to be based upon quote-unquote confession taken in captivity without proper legal representation and in absence of consular access sought by India. If we closely follow the reports in the media in Pakistan, we can get the sense that an increasing number of death sentences awarded by military courts in Pakistan have been carried out after 10 April 2017. That's when the death sentence to Mr. Jhadav was confirmed. In fact, over the past 1 month, 18 such executions have been reported through press releases issued by the Inter-Services Public Relations, the military spokesman of Pakistan. In such circumstances, including where there is no response to the requests made through diplomatic channels, there is an immediate threat that death sentence against Mr. Jhadav may be carried out even before India has the opportunity to be heard and the court has a chance to consider the merits of the case, and thus causing irreparable prejudice to the rights of India and Mr. Jhadav.